Greetings, my fellow freedom lovers, sovereign thinkers. It's LL3's newest podcast. My name is Craig, transmitting from the beautiful swampy mango of South Florida, and today's date, Friday, August 24th, 2018. So let us begin. All right. Nice warm day in Fort Lauderdale, Florida. August, almost September, just around the corner. Plus, I'm at Stash, located at 109 Southwest 2nd Avenue in the heart of Fort Lauderdale, Hemmershey District, which is adjacent with Revolution Live and America's Backyard. Yeah, I was just starting to really laugh when I hear, reading some of these websites, and of course Vox and Unicorn Riot, which is very disappointing when they talk about, the white supremacy thing that was going on in South Africa is a hoax, stolen land and all that. And people folks are being slaughtered or being murdered. What's very funny about that, because now they're all saying the white supremacy thing. How come they didn't have to talk about this the past 18, 20 years? This stuff been going on. Doesn't matter who is getting slaughtered, it's completely dead wrong. These folks there better get their facts straight before talking out of their rear ends. And I say that in good faith. You can fact check Snopes and all that good stuff, but you know what? It's pretty damn useless, with all sincerity. Yeah, I was just reading this link on Unicorn Riot via Twitter. And it's very disturbing when I hear this one-dimensional garbage. I have a question for those particular sources, so-called reporters, in this particular subject matter. Can you explain to me why the Cape Province seceded from South Africa to start a new country entitled the Sovereign State of Good Hope, acronym SSGH, on September 27th, 2017. In addition, King Cornelius III actually went to one of the Parliament provinces and put a notice of eviction, an eviction notice, to the folks of South Africa, then had that group took down their South African flag and raised their own. And you got folks from Colored Nation, Eurokaners, Afrikaners, stood as one. Explain that to me. So if you think it has something to do with neo-Nazism, about the white people being slaughtered, they're a bunch of damn fools. You need to be ashamed of yourselves. You need lots of more merit before putting stuff like that out. I'm not going to tell you what to do, but it's very disheartening. Don't get me wrong, Unicorn Riot, even Vox, they have their pros and cons like everyone else. But the truth of the matter is, my friends, they better back it up, because there's nothing new what's going on in that horrific events occurred in Africa. It's just an example. It's happening worldwide, even with the Uyghur group that maybe getting to being victim of ethnocide or genocide by the Chinese government. Same thing. I condemn it. There you go. You can't say I'm a Nazi sympathizer or a white nationalist. Period. So if you folks want to defend them, you know what to do. Email me with merit instead of being a parrot. Alright. Listen to some little cool jazz I hear in the background. Pretty cool. I like it. Well, you know what? I'm mainly be talking about some of the freedom aspects of what's going on, and a little thing about the whole Manafort Cohen conviction, which I tried to do yesterday, the last show, but I had a lot of compromise on my app. I had too much stuff in my hard drive, so I had to do a little transferring, and techno cleaning. I got a good amount of it out. I still need a lot more work, but it's better than before. Alright, so let's begin here. From the Rutherford Institute, this one's entitled Justice is Not Neutral. Rutherford Institute issues in-depth report most significant rulings from the U.S. Supreme Court's 2017-2018 term. Came out today. In Washington, D.C., of course, in the light of major changes taking place at the U.S. Supreme Court, the Rutherford Institute has released a new report that examines the significance of the Court's most critical rulings handed down during its 2017-2018 term. Justice is Not Neutral provides a detailed analysis of some of the most critical rulings handed down within the past year, especially as they related to the First and Fourth Amendment rights. What difference 9 people can make. Given turbulence of our age, with its police overreach, military training drills on American soil, domestic surveillance, SWAT team raids, asset forfeitures, wrongful convictions, profit-driven prisons, and corporate corruption, the need for a guardian of the people's rights has never been greater, said the constitutional attorney John W. Whitehead, president of the Rutherford Institute and author of Battlefield America, The War on the American People. One moment. So, as it reads here, American founders intended the courts within the American judicial system to serve as courts of justice. What we have been saddled with, however, are courts of order. This is true at all levels of the judiciary, but especially so in the highest court in the land, the U.S. Supreme Court, which is seemingly more concerned with establishing order and protecting government interests than with upholding the rights of the people enshrined in the U.S. Constitution. Justice is Not Neutral examines the ramifications of the Supreme Court's most consequential rulings from the 2017-2018 term, especially as they relate to speech, religious liberty, and the First Amendment, police misconduct, privacy, and the Fourth Amendment, immigration and the power of the presidency, states' rights, voters' rights, and gerrymandering and commerce. As Whitehead points out in his introduction to the report, we have come a long way from Justice William O. Douglas' view that the Constitution and in turn the courts are supposed to take the government off the backs of the people. For most Americans, justice remains out of reach, while the courts themselves remain out of sync with the spirit of the Constitution. For instance, in recent years, the court has ruled that police officers can use lethal force in car chases without fear of lawsuits. Police officers can stop cars based on and only on anonymous tips. Secret Service agents are not accountable for their actions as long as they're done in the name of security. Citizens only have a right to remain silent if they assert it. Police have free rein to use drug-sniffing dogs as search warrants on leashes, justifying any and all police searches and vehicles stopped on the roadside. Police can forcibly take your DNA whether or not you've been convicted of a crime. Police can stop, search, question, and profile citizens and non-citizens alike. Police can subject Americans to strip searches, no matter the offense. Police can break into homes without a warrant, even if it's the wrong home. And it's a crime to identify yourself when a policeman asks your name. The Rutherford Institute remains a consistent and persistent voice advocating for the rule of law and working to restore America's judiciary to its rightful role as an institution that intervenes and protects we the people against the government and its agents when they overstep their bounds. As such, the Rutherford Institute's report, Justice Not Neutral, along with this ongoing Constitution Q&A series, also available at rutherfordinstitute.org, is part of the Institute's ongoing effort to educate the American people about their constitutional rights, to warn of the dangerous trends that threaten their freedoms, deeply committed to protecting the constitutional liberties of every American and the integral human rights of all people. The Rutherford Institute strives to make justice accessible for all Americans by sounding the alarm over government misconduct and working in and out of the courts to make the government play by the rules of the Constitution. So I have took a little glimpse. You could read the document yourself. justice is not neutral. About 12 pages long, maybe 10 I would say to be exact. And some interesting cases here which I admire. And they tell about, of course, John Whitehead, introduction and all that. And a lot of stuff has been occurring here. So I'll just go down some of the cases they talked about. Right here, of course, speech, religious liberty, the First Amendment, Masterpiece, Cake Shop, Limited versus Colorado Civil Rights Commission. And, of course, the ramification of that, individuals should not be discriminated against by any branch of government because of their religious beliefs. The baker was entitled to a hearing before impartial decision makers who would not be affected by the personal opinions about the baker's beliefs. The rights of individuals to subject to something they believe is wrong, especially when it contradicts their religious beliefs. Whatever it's a war on abortion, homosexuality, or a number of other issues, and the right of the freedom of conscience because of those religious beliefs is guaranteed under the federal law and under the First Amendment of the U.S. Constitution. And it's always good to know about these things, my friends. You should always look at the state constitutions as well. And they do have like a Bill of Rights article too, if I'm correct, in that state of Colorado. And of course, the inherited rights, enumerated rights, and of course, free speech, etc. So you can use that as well, because sometimes there's some ordeals when they try to use the federal, take a state, local issue and bring it to on a federal level, the federal court. And technically, it's nothing more what you're doing. What Michael Maharry, and I have to agree with him respectfully, is a corporate doctrine. And that's one thing you gotta watch out for, because you will try to focus in your jurisdiction, then you can make that impact. It won't affect everybody, because the whole thing is, the Supreme Court can say whatever they want, but the state level can say, no, we don't have to do that. Another great case, too, which I talked about in my past episodes, Blowsman versus the city of Rivera Beach, Florida. And of course, the conclusion, which, and here the Supreme Court ruled in the favor of Lozman, asserting that a probable cause to arrest Lozman for disruption did not prevent him from claiming that counsel's arrest was retaliatory in a violation of the First Amendment. Ramifications for that on the day of the key ingredients in the democracy is this right to freely speak our minds. Speak our minds to those who represent us. In fact, it's one of those few effective tools we have left to combat government corruption and demand accountability. But now that even that right is being chipped away by statutes and court rulings, which weaken our ability to speak freely, activities which were once considered a major component of the democratic life in America are now being criminalized. Making matters worse, politicians have gone to great lengths in recent years to evade their constitutional duty to make themselves available to us and to hear our grievances. This is what represent government is all about. Government action that is meant to silence dissent is an abuse of power, even if some justification can be conjured to explain an arrest if the true reason for the arrest is censorship, and then the First Amendment is violated. And that one there is Article 1, Section 4, free speech, of course, and right to peaceful assembly is Section 5 of the same article. And another thing you got to look at, too, they actually breached Lozman's basic rights, okay, on that. You have the right to criticize these elected stooges. And I can say that in good faith. And one more thing you have to look at, too, that the commissioners of the Riviera Beach that supported this arrest officially breached their oath under Article 2, Section 5 of the same document, which is, once again, the Florida Constitution. Hey, I say recall these yahoos, but I know that at least with that, a lot of them got voted out, which is good. You got to put these parasites on track. Keep them on their toes. Like, remember, in my past episode, I read a good article on News Reviews. Do you trust your government? Do you trust the government? And there's one thing guys say, never trust them, period. And we could even hit another one here. It's in reference to, some pros and cons here. But I'll do a couple more. This one here is mainly about, Carpenter versus U.S. And it's mainly about Timothy Carpenter was arrested of an armed robbery as the Carpenter provided cell phone numbers belonging to other alleged suspects. Police obtained a court order under Stored Communications Act. Okay, and what's interesting about that, the location of evidence was used at Carpenter's trial to convict him of robbery. And the fun thing about that, they never actually had a quote-unquote warrant. That's what the Rutherford Institute weighed in on the case. And, of course, the data tracking person, the Supreme Court ruled in favor of Carpenter, asserting the government violated the Fourth Amendment when it's obtained cell site location information without a warrant and without showing probable cause. And, well, I don't know where this one happened at. I think, okay, United States. And what's interesting about that ramification, the court's ruling sends a strong message about privacy rights in the age of government surveillance and signifies victory for the right of warrantless searches and seizures by government agents, not only but in their persons, houses, papers, and effects, but also has the right to privacy pertains to the ever-evolving technological realm, the new era of surveillance and technology, one that was completely unimaginable to the men who drafted the Constitution and the Bill of Rights, requires an updated legal code enshrining the right to privacy. You could add the Ninth Amendment as well, called enumerated rights. So it's right there, checkmate. And we'll go a little bit further down here. I'm just trying to hit maybe a couple more. This is more like a Fourth Amendment stuff. And Daha versus U.S. In Kansas, two brothers were indicted for conspiracy to distribute marijuana. Some of the evidence against the brothers was obtained under a federal court that allows cell phones to be wiretapped. The order, however, allows surveillance occurred when the phones were not in Kansas. The Butt brothers moved to suppress the evidence obtained under a wiretap order, arguing the order violated federal law that limits wiretap surveillance outside the court territorial jurisdiction. Rutherford Institute urged the Supreme Court to strictly enforce the nation's federal wiretapping law and maintain court privacy. This is a conclusion, just to let you folks know, enacted by Congress in 1968 to guard against the misuse of bugs and wiretaps by government agents. However, the U.S. Supreme Court was unmoved, ruling that the wiretap order issued by a judge was valid because the order did not lack any information the wiretap statute required them to include. Where's the ramification of that? We now found ourselves operating in the strange paradigm where the government not only views the citizenry as suspects, but treats them as suspects as well. Thus, the news that the National Security Agency and its intelligence counterparts routinely operate outside of law and overstep their legal authority by carrying out surveillance on American citizens is not really much of a surprise. This is what happens when you give the government broad powers and allow government agencies to routinely sidestep the Constitution, yet unlawful surveillance of any kind by the government and its corporate partners in crime hasn't made America any safer, and it certainly isn't helping to preserve our freedoms. Whether or not surveillance is undertaken for the innocent reasons, surveillance of all citizens, even the innocent sort, gradually poisons the souls of the nation. Surveillance limits personal options, denies freedom of choice, and increases the power of those who are in a position to enjoy the fruits of this activity. J. Edgar Hoover, who was a Nazi sympathizer, would be extremely proud. So I'm going to probably down here, they have some stuff on rights of the accused. Yeah, rights of the accused here. Let me see. Yeah, I'm going to do one here is McCoy versus Louisiana. It says, here's the facts. In May 2008, Robert McCoy was arrested for first-degree murder, maintaining his innocence and desiring to plead not guilty. McCoy was advised by his counsel to take a plea. McCoy refused and asked the court to discharge his counsel. The court denied McCoy's motion, and his counsel proceeded to concede McCoy's guilt over McCoy's explicit objections. The conclusion, Supreme Court sided with McCoy, ruling that as a violation of the Sixth Amendment right to counsel for an attorney to concede the defendant's guilt over the express objection of the defendant. Ramifications, the Constitution requires that defendant receive effective assistance from his attorney, and the defendant does not receive the level of assistance if his attorney fails to protect the defendant's rights to be presumed innocent. Because the text of the Constitution permits all criminally accused defendants to have assistance for counsel, the defense, the U.S. Supreme Court, has determined that a criminally charged defendant who is unable to afford an attorney shall have an appointed free of charge if he or she desires. The reasons behind these rights are twofold. First and foremost, the defendant benefits from a speedy and public trial by jury because an open trial suggests a fair hearing of his or her grievance. Second, democratic society believes from ability to witness local courts, law in action. And I want to do one more here. Yeah, I do two more here. This is pretty interesting as well. We can do here about states' rights. Murphy versus National Collegiate Athletic Association, or NCAA. And it talks about the legislators backed by the will of the voter to move to legalize sports gambling schemes within the states. However, federal law, the Professional Amateur Sports Protection Act, prohibits most state-sanctioned sports gaming. The NCAA sued New Jersey, seeking a declaration that the law allowing sports gambling in the state was invalid under this federal law. The conclusion for that is the Supreme Court ruled in favor of New Jersey, holding that parts of the PAPSA violate the 10th Amendment anti-commandeering rule that forbids Congress from mandating what laws states may or may not enact. So technically what they're doing is a government overreach, which Federalist Papers 46 has talked about, written by James Madison. Of course, Prince versus the United States as well. I'm just giving you his history lessons here, too. And folks, you can take a chance to check it out. It's really good stuff. And, of course, the ramification of that, federal government's powers has expanded far beyond what the framers of the Constitution intended. This ruling is a triumph for federalism and returns authority to states. The 10th Amendment reserves to the states and the people the powers not delegated to the United States by the Constitution, not prohibited or nor prohibited by, although this case was factually about the rights of the states to legalize sports gambling despite a federal law prohibiting it. The ramification of the ruling could extend into the area of marijuana legalization. And we'll do one more here about human rights. Janssen versus Arab Bank. In recent years, facts of recent years, several foreign nationals have been injured, kidnapped, and killed by terrorist attacks and that occurred outside the United States. Family members and survivors accuse Arab Bank of financing the organization involved in these attacks and sued Arab Bank under the Alien Tort Statute, a federal statute that allows foreign citizens to seek justice with the American courts for human rights violations. Conclusion: the Supreme Court had ruled in favor of Arab Bank, arguing that the Alien Tort Statute does not allow lawsuits against corporate defendants. Ramifications: the court failed to affirm the foundation principle that corporations are not above the rule of law and should not be used as a vehicle to circumvent domestic or international laws that punish participation in egregious human rights violations. Permitting corporations to escape civil liability for crimes against humanity is a fundamental departure from the constitutional theory of the rule of law upon which the U.S. Constitution rests. We have operated too long under a double standard that favors corporations, recognize them as persons for the purpose of profit, but failing to hold them equally accountable for their abuses. This discrepancy gives corporations carte blanche authority to operate above the law. What's interesting about that, when he talked about corporations of people too, that's under Title 28 U.S. Code Section 3002. Just read it in its entirety. That's how they got the ruling about corporations are people. So it's very disturbing at that, because there's a lot of doublespeak here as well. So you got to look at the pros and cons of what the Supreme Court did. They did good and they did bad. So we have to learn from the bad and make it better and try to even bring it on the state and local level. So there's one thing you got to look at these areas. They'll never try to make these areas like a local, like if it happens in your state, try to use it in those areas. Go through those remedies, because then you got better opportunities and the message can be clear. Because remember, it's all about states' rights, etc. So so it's very interesting here on this, and you could actually see this for yourself. Is about on this Supreme Court rulings. So that's just giving you some of the areas. I'm not going to read everything in its entirety, but you can definitely, I'm going to post this on my Spreaker page and all that, and there's a link for it, and you can read it in this all the way down. It's very good stuff. All right, well, next one here came from Jason Hornberger's blog, The Future Freedom Foundation, was the recipient of the Ron Paul Liberty and Media Award. All right, it says here, any conspiracy theorist in the JFK assassination. One of the most fascinating aspects of the Kennedy assassination has been any conspiracy theorist, especially within the mainstream press. People are so scared of being labeled a conspiracy theorist that they will do everything they can to avoid making careful examination of the circumstantial evidence pointing toward a national security regime change operation in Dallas on November 22nd, 1963. Consider, for example, Sandra Spencer, who I discuss in both my books, The Kennedy Autopsy and my current ongoing video podcast series on the JFK assassination. Some links on here, so check it out, folks. Spencer was a Navy petty officer who was serving in the U.S. Navy photography lab in Washington, D.C. In November 1963, she had a top-secret security clearance. Her job included the development of classified photographs. She worked closely with the White House. It would be virtually impossible to find more credible and competent witness than Sandra Spencer. No one has ever questioned her veracity, integrity, and competence. As most everyone knows, when someone in the military acquires what is known as classified information, he is required to keep it secret for the rest of his life, even if he leaves the military. Every member of the U.S. military, indeed every employee of the U.S. national security establishment, knows that if he ever breaches the secrecy principle, he is subject to serve punishment. In 1990, Spencer was summoned to testify before the Assassination Records Review Board, the commission charged with enforcing the JFK Records Act, which forced the U.S. national security establishment to disclose its records relating to the JFK assassination to the public. Spencer related an outstanding story, one that she had kept secret for some 30 years, owing it to its classified nature. After the ARRB released her from her obligation to secrecy, Spencer stated that on the weekend of the assassination, she had been asked to develop on a top-secret basis the photographs of the autopsy that the U.S. military had performed on President Kennedy's body on the evening of the assassination. The ARRB's general counsel showed Spencer the official autopsy photographs, which she carefully examined. She stated directly, firmly, and unequivocally that those autopsy photographs were not the autopsy photographs that she had developed on the weekend of the assassination. The one she developed, she said, showed a large exit-sized wound in the back of the President Kennedy's head. The official autopsy photograph showed back of Kennedy's head to be intact, that is, without a large exit-sized wound. What are we to make of this? Well, according to any conspiracy theorist, nothing. We are not supposed to go down that road. We're not supposed to ask any questions. For to do so would mean that we have entered the dreaded realm of conspiracy theory. Even the fact that the treating physicians at Dallas Parkland Hospital, who described a large exit-sized wound in the lower back of the president's head, from which they said was leaking cerebellum, which is the lower back part of the brain, is not supposed to cause us to wonder what is going on here. That could lead down the dangerous road of being a conspiracy theorist, as shown in the Dallas businessman Abraham Zapruder's famous film of the assassination. Immediately after the president was shot, Secret Service agent Clint Hill grabbed onto the back of the presidential limousine, pushed Jacqueline Kennedy back into her seat, and put his body on that of President Kennedy in an attempt to shield the president from any more shots. For the 6 to 8 minutes that it took to get to Parkland Hospital, Hill said he was staring at the large exercise wound in the back of the president's head. But we can't go there either. That makes us a conspiracy theorist. Parkland nurse Diana Bowron was one of the hospital personnel helping to get the president out of the car and into the hospital, where she put her hand Behind the president's head, she felt a large exit-sized wound in the back of the Kennedy's head. Nurse Audrey Bell was helping the treating physicians inside the hospital. She later emphasized large exit-sized wound in the back of the JFK's head. Don't even think about Bowen, and Bell said it could make you a conspiracy theorist. Charles Brem was a bystander who was situated to the left rear of the presidential limousine when the president was shot. He saw, for the lack of a better term, exit debris from the wound in the back of President Kennedy's head landing in the grass near him. A woman named Marilyn Willis, who was also behind the limousine, that she saw the exit debris coming out of the back of Kennedy's head. Her daughter said she saw the backside of the president's head blow out. A motorcycle cop named Jimmy Hargis, who was situated to the left rear of the vehicle, got splattered with exit debris. Don't go down that road. Remember conspiracy theory. Remember conspiracy theory. FBI agents Francis O'Neill and James Siebert were at the autopsy that the U.S. military conducted on President Kennedy's body. When the AARB showed them the official autopsy photographs, they said that the autopsy photographs were incorrect because they failed to show us the massive damage to the back of the president's head. One of them used the term doctor to describe the photographs. Just forget their testimony. It could lead you to being considered a conspiracy theorist. In 1966, the official autopsy photographer John Stringer was summoned to a meeting, confirmed an inventory of the official autopsy photographs, which are still being kept secret from the American people. After reviewing the inventory, Stringer said it wasn't accurate because it did not include all of the autopsy photographs he had taken. He was ordered to sign it anyway, which he did. When the AARB asked him in the 1990s why he signed the inventory knowing that it was false, he said he did so because he was ordered to do so. So he was a bone fetcher, bellboy, right? And the AARB General Counsel pointed out that some people in the military say no to such things. Stringer responded that such people don't last long in the military, but you're not supposed to wonder all about this. You're not supposed to question it. After all, why take the risk of being called a conspiracy theorist? Isn't it much safer to remain an anti-conspiracy theorist, even if that necessarily means that you believe that all of those people must have gotten together to concoct for some unknown reason the wound in the back of the President Kennedy's head? Well, right? Of course, a lot of us are pretty familiar with that. It's been so obvious. But remember, you're a conspiracy theorist if you believe his head wasn't blown off, right? Yeah, that's how he died. He didn't die that way. It came from the back of the head. And when you use the Patsy Lee Harvey Oswald, he was a lone shooter. Come on. Even some of the redacted information that was come from the Kennedy files, he did say the same thing about. They said it was like multiple shooters. So that's one area people talked about for years. That just has come to light. So we all know he got taken out just like Abe Lincoln because they pissed off the banksters. Now you know me, I was real critical on a lot of Lincoln's actions as president too, but when it came to the banksters, I cannot argue on that because that is how it goes. So, am I a conspiracy theorist? Hey, I wear it with the badge of honor, but I'm not going to go anything as conspiracy. But like what I said about 9/11 was a New World Order agenda, a lot of people thought were laughing at me. Not anymore. Not saying I'm better than them. Absolutely not. I just seen right through them. Yes, I've been a 9/11 truther for close to 17 years. It will be on September 14th. Okay, so September 14th, 2001, I declared that September 11th as a New World Order agenda. Call me a conspiracy theorist. I'll be so flattered. And I go, thank you. I'm inspired. Okay, so I'll be right back. So stay tuned. All right, folks. So the next thing I'm going to be addressing here, tried to do this yesterday, but things just happened along the way. But I guess this is important. This came from Personal Liberty. Manafort conviction and Cohen plea. Sound and fury signifying nothing. This is by Bob Livingston. While conviction of the Manafort and the plea deal struck by Michael Cohen gave the fake news media inflated ratings and fodders with which to gin up the deluded Democrats and the Never Trump crowd, when boiled down to their basic elements, there is nothing there to legally hurt President Trump. Special Counsel Robert Mueller treated Manafort worse than their own crime boss, raiding his home in the early morning, piling on charges, and locking him away in solitary confinement while he waited trial. Can we say, yeah, torture? Yeah. Mueller threw everything at Manafort but the kitchen sink, hoping beyond to get him to tie Trump to some Russian collision. What he got was a conviction on bank fraud, money laundering for activities long before he signed on to the Trump campaign. So this has all been happened before. The activities he was convicted of occurred under Mueller's nose while he was FBI director. Manafort's partner in Ukraine, from which the charges stem, was one Tony Podesta, a Democrat operative who was hovered in the Bill and Hillary Clinton orbit for decades. Podesta still has not been charged with a crime, but his political organization's PR firm has gone belly up. Can we say bias, discrimination, bigotry, oh my? Continue on here as the Washington Examiner's Brian York writes. Mueller did not allege any links or coordination between the Russian government and individuals associated with the Trump campaign, and none were revealed at the trial. That's not to say the public did not learn anything from the Manafort trial. Indeed, if nothing else, outsiders got a glimpse into what Washington-influenced peddlers have gotten away with for decades. Manafort was convicted for shady dealing going back a long way. His behavior has been examined by the Obama Justice Department, which took no action against him. It was only because Manafort hooked up with Trump, and Trump then won the White House, and Democrats then pushed a Trump-Russia narrative to hobble the new president. And Trump then fired the director of the FBI. Only through all of those circumstances that Manafort got caught up and his foreign money schemes exposed. The importance of the financial crimes against Manafort was never the financial crimes themselves, but it was the prosecutor's hope that by charging the hell out of the offenses alleged by playing hardball, would defend it with a guns drawn at dawn search warrant raid by jailing him over debatable obstruction of justice, and charge that Manafort could be pressured into spilling what prosecutors apparently thought were a lot of beans about the Trump campaign and Russia in the 2016 election. But the beans weren't there, so Mueller's team turned to Cohen. He and his hack lawyer, Lanny Davis, a longtime Clinton fixer, spokes puppet, and bagman, copped a plea to campaign finance crimes. Cohen has been all over the board with this, saying months ago that payments to women to claiming affairs with Trump had nothing to do with the campaign. Now he's flipped his script, which has made the political left flip its lid again. But even the fake news, Washington Post is forced to admit that Cohen's plea probably will not have any legal consequences for the president while he's in office. According to a legal analyst, the Department of Just Us, has long held that sitting presidents can't be charged with a crime. Mueller has said that campaign violence violations are outside the scope of his mandate. That's one reason he pushed the Cohen case off on U.S. attorneys in New York. And Deputy Attorney General Rod Rothstein has admitted that Trump can't be indicted. And besides, if a campaign finance violations occur, prosecutors would have to prove that Trump knew that the payments violated campaign finance laws and instructed Cohen to make them anyway. When the Federal Election Commission ruled on the John Edwards case in 2012, Edwards was charged with making payments to his mistress, with whom he had a son, to keep her quiet during the campaign. It found out that the payments were not campaign contributions. If anything, Trump's payments only amount to civil violations, not crimes, and Trump will be forced to pay a fine, as Barack Obama did for not reporting campaign contributions in 2008. So that's fair enough, right? Absolutely. As former Bill Clinton pollster Mark Penn notes, Cohen's plea involves pleading guilty to a corporate contribution he did not make, coordinating a payment to Karen McDougal by American Media Inc., and one that he made on October 27, 2016, days before the election, that would not have shown up on the campaign finance documents until long after the election was settled. And it was a payment Trump and Cohen had been working on for 5 years. Meanwhile, none of Hillary Clinton's campaign finance documents make mention of the millions of dollars paid to the Perkins Coie law firm, which laundered that money through Fusion GPS to a former British spy working with Russians to find dirt on Trump. Nor do we know, are any Clinton operatives the targets of investigations by a special counsel, or at least so it seems, the feckless Attorney General Jeff Sessions. While none of this implicates Trump beyond guilt by association, it provides shiploads of ammunition for the further division of right and left, and plenty of campaign implications for this fall. And that's probably exactly what the deep state wants. Drive each other crazy, separate us, and they'll sit there and laugh. Those are one of the areas you gotta really see, my friends. It was nothing more than a dog and pony show, and Christine and J.C. Hall attest. They did say that it was more of a political coup attempt. That's how I see it too, and they're right. But we all know too about Mueller. He is not a great patriot, what people say. People need to question him about the 9/11 ordeal that happened with the Sarasota connection. Yeah, he was involved in that. Dropped the ball. He had knowledge. Yeah, you people are going to say he's a great man? Give me a break. So, that's one of those areas you have to really seek. Hey, I'm not here being a Trump worshiper either, and his rhetoric was pretty bad. All right, his tweets are hilarious. If you take him too seriously, you're going to get gray a lot quicker. But this whole Manafort and Cohen ordeal, all these Trump haters are manifesting, climaxing, getting hard-ons, getting orgasms, etc. I just sat back and laughed. So that's all I have to say. It's all pre-Trump. That was the only thing. So the whole Russian collision is nothing more than a sham. S-H-A-M. In other words, a rhetorical deception. If it was Israel, they'll be giving him a ticker tape parade. Okay? Enough of that. Yeah. All right, friends. So one more thing I'm going to be doing. And this one here came from the Independent News International. And this one came out yesterday. It says here, beware of any proposed con. It's by Michael Badnarik, who was the 2004 Libertarian Party presidential nominee. The check is in the mail. Of course, I'll respect you in the morning. A convention of states will restore our freedom in America. Only an idiot will believe any of these. They are sweet-sounding promises that are nothing but lies. Article 5 outlines how individual changes can be made to the Constitution. It requires 3/4 of the state legislators to ratify any amendment, making it very difficult to alter our supreme law. This was deliberately intended. Remember the ERA amendment? It floundered in debate for years before it died completely. A convention of states will not make individual changes to the Constitution. It will allow the document to be rewritten completely. Who do you think will be making those changes? You? Of course not. You probably don't even know how many articles are in the Constitution. You are hardly qualified to make improvements to a document you don't understand. Only the corrupt, power-hungry in Washington will be there to enshrine their control over you in that document. That is because you are so easily swayed by a piece of paper. Once their collectivist ideas are written in paper, you go along blindly because it's in the Constitution. Congress has a responsibility to declare war, but World War II was at least time they did so. That means Korea, Vietnam, Afghanistan, and numerous other examples are all unconstitutional military excursions being waged with their tax dollars and under your presumed authority. The Constitution explicitly requires gold and silver to be used as a currency so that our money cannot be counterfeited. In 1913, bankers fraudulently created the IRS and the income tax, and the Federal Reserve Act granted a private corporation a monopoly on counterfeiting our money. This is the root cause of our economic problems, but very few people truly understand that. The Constitution originally required senators to be appointed by the state legislators for the explicit purpose, preventing the federal government from assuming powers that threaten the authority of the states. Yeah, so as I continue here, the 17th Amendment was also established in 1913, allowed the people to vote for senators, eliminating an important check on the balance of power. Now we have a large House of Representatives and a small House of Representatives, and our cherished republic was turned into a democracy. Americans foolishly did this to themselves. Since then, the federal government has grown exponentially, and newspaper articles now falsely claim that the Supremacy Clause in the Constitution gives the federal government more authority than the state governments. Nearly everyone believes this lie to be true because they fail to study and understand the revolution that separated us from England. Keep in mind that the state governments create the federal government as their servant. It is illogical to assume that the states gave federal government authority over themselves. Utter nonsense. The Constitution isn't badly broken, it is simply being ignored. It is being ignored because Americans are making an emotional decision with little or no understanding of the unintended consequences. The proper course of action is to enforce the document, not change it. Indict and jail the members of our government who casually ignores the oath they took and violate your rights with impunity. The real question is, do you have the courage to do that? You are beautiful but naive, Snow White. The people in power are the evil witch, and the Convention of States is the poison apple they are offering you. Do you really want to take a bite? Something to think about, my friends. We don't need a constitutional convention. It's nothing more than a monumental lie. And Mr. Bednarik is absolutely correct. I've seen him spoke a few times on C-SPAN and all that, and even some of his interviews. He's very good. He even tells the state, hey, I don't need your license. I can drive wherever I want because it's my right to travel. People like that have guts. We all got to choose our battles wisely, but we're being conditioned that we have privileges, not natural-born rights, and they know better because they're complaining to be attorneys. All you got to do is read the supreme law of the land, plain and simple. Not this day and age garbage either. It's null and void. The framers who wrote it, James Madison, and many of us have foresight. They see the bigger picture. They're not morons. So we got to uphold our oath as registered voters as well, to protect and preserve both U.S. Constitution and state constitution that you're in. That is our obligation. Who cares who's blowing who's associated with President Trump, anything, and when Trump farts, people want to have a spaz out. Come on. Get with the program, my friends, because you know why? They want you to be dumb, stagnant, happy, and just be a bunch of complainants without any actions. To me, that makes all of us weak and pathetic, and I know we are not. All right. I thank everyone for listening. Plus, feel free to download and share throughout your social media networks. Have any questions, comments, or you send me something that's interesting you want to check out? Whatever you do, please feel free to correspond me with Decorum. Hit me on all the websites, social media sites I'm going to put on my Spreaker page, and many others. In addition, you can email me at LokiLuck3@gmail.com or to your cryptid ones, Proton mailers with a Proton mail account, LokiLuck03@ProtonMail.com. All right, my friends. Once again, thank you for your time. Plus, always remember that the demoniac resistance is healthy for the soul. You can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love, and may your guardian spirits be with you.